All right, this is case number 15-120-830. This is Razor Capital versus Michelle Baker, also known as Michelle M. Baker. The matter is set on today for review regarding objections to a writ of garnishment. Your appearance for Razor Capital, please.
Yes, good morning, Your Honor. Joseph Jamal on behalf of the plaintiff.
And your P number, if you will, counsel.
Yes, P71254.
All right, thank you, sir, and good morning to you. And do I have Michelle Baker on the Zoom at this time? Ms. Baker, Michelle Baker. All right, counsel, update me on what's going on here, sir.
It doesn't look like there's been much action since the garnishment was filed. We did discuss setting up some payment terms with the defendant. She has provided some disputes as well, but nothing's really come to fruition since really this filing. All right.
So yeah, I think I adjourned it over with some agreement that some payments would start at $250 monthly. Are there any payments being made at this time?
That is correct, Judge. It looks like she did make one payment, voluntary payment of that was $20 made back in July. We have been in contact with her. It looks like the last contact we had was in September, and she indicated that she was going to be checking into the payments, but we have not heard back.
Your pleasure regarding this matter, sir.
Yeah, at this point, I guess I'd request any sort of objection to garnishment be denied at this point, and if payments don't begin, we'll just proceed to the garnishment again.
All right. Given the scenario that's been set forth before the court and the fact that the defendant, notwithstanding the fact that she's received notice in this regard, has not appeared for this review hearing on the objections to garnishment, the status of this matter appears that no payments of any significant have been made in avoidance of the execution of the garnishment. Therefore, the court will deny the objections at this time and will allow the writ of garnishment to go forward and will lift any suspension in that regard. So, and I'm signing an order to that effect at this time, counsel.
Great. Thank you, Judge.
Sure.
Okay.
Should be registered action.
Okay.
The court now calls case number. This is 5. So, just one. That's the appropriate information.
Okay.
You don't need that.
I don't need this one. Okay. All right.
The court now calls case number 21-140-786. This is Michigan Comprehensive Spine versus City of Detroit. Matters before the court set on for review. I believe the court may have adjourned the final pretrial conference. set the matter for review on today's date. For the plaintiff in this matter, Michigan Comprehensive, your appearance at this time, please.
Philip Jaffe for the plaintiff.
And Mr. Jaffe, if you will, your P number for the record, sir.
25997.
All right, thank you, Mr. Jaffe. Good morning to you. And for the city of Detroit, your appearance, counsel.
Morning, Your Honor. Alfred Ashew on behalf of defendant, PA 2536.
All right, thank you, Mr. Ashew, and good morning to you as well, sir. The two of you are here, and I don't see a lot of smiles or anything, but maybe that's not true.
Well, Your Honor, if I could just fill the court in. We last appeared, there was a motion that defense had filed. We were trying to get a deposition. Mr. Jaffe has graciously provided a deposition date. So we are scheduled to take the deposition coming up, and that's where we're at right now.
All right. So, Mr. Jaffe, anything, sir?
No, the deposition is scheduled for November the 2nd
All right, very well.
of a doctor at plaintiff's facility.
All right, great. All right, so why don't I go ahead and set it out for the 30th of November. Let's take a look at it at that time. That'll be Tuesday, November 30th. And I'll set the matter on at 9:30 a.m. The court finds good cause for adjournment of this matter in light of the scheduled deposition, and there being no objection to the parties mutual. All right, so we'll see you on the 30th of November at 9:30 a.m.
Thank you, Your Honor.
Thank you.
Stay to the tour. All right, the court calls case number 21-154390. This is Smartway Auto Incorporated versus Andre Jameson. The matter is before the court where there was filing of a motion to set aside a default judgment. The court did take that motion under advisement and set the matter on for hearing on today's date. For the plaintiff in this matter, your appearance at this time.
Good morning, Your Honor. Cara Moody, P number 81239, here on behalf of Plaintiff, Smartway Auto.
All right, thank you, Ms. Moody, and good morning to you, ma'am. Do I have on the Zoom Andre Jameson? Say something if you're on the Zoom, please.
How you doing, sir? My name is Andre Maurice Jameson.
All right, thank you, Mr. Jameson, and good morning to you as well, sir. This is, in fact, your motion to set aside the default judgment in this matter. The record would reflect that that judgment was entered on the 26th of August, 2021, where it was set forth that the defendant had not appeared or otherwise responded to the complaint in this matter and or did not appear for a hearing. Let me understand the basis upon which you believe the judgment should be set aside in this matter. Mr. Jameson, you may at this time, sir.
Yes, Your Honor. I originally went up to the courthouse on the date of the original court case. I was given, I was given bad information as far as what number to come in on the Zoom call. And I was actually at that address of the Zoom call address. I spoke to Your Honor around 1 o'clock in the afternoon. Once I was able to get back in touch with the courthouse, and they gave me a new number, which I spoke to you. And I was instructed to put in the motion once something from the court came in the mail. And once it came in the mail, well, actually it never did come in the mail. I just took it upon myself to go back down to the courthouse and found out that the default judgment was put in, and I decided to put the motion in.
All right, sir. So essentially your good cause that you are asserting in this matter is that you received some misinformation and that your failure to appear at the Zoom hearing was as a result of the fact that you didn't have the correct information to appear. appear, correct, sir?
Yes, sir.
All right, now, there are two things that you have to show when you file a motion to set aside a default judgment. One is good cause, and the other is that you have a meritorious defense. Tell me about why the plaintiff should not be entitled to judgment in this matter. What is your defense to the claim that's raised at this time, sir?
Well, Your Honor, on the week of May 18th, the vehicle in question, which is a 2007, or rather 2007 red Chevy Impala, the vehicle was a leased vehicle. The water pump went out on the vehicle. So I took it, I did what I was supposed to do, and I took it to the shop to get the water pump put in. And that was May 17th. I paid $165 to put the water pump in. Once the water pump was put in, the engine was cracked. That's why the engine stopped. It was cracked. I got an estimate from the same place. I then called Smartway and explained to them what was going on with the vehicle. The estimate for the engine to be fixed was $902. I was instructed by Smartway, representative of Smartway, that they were going to take care of it. They even sent a tow truck out to my residence and took the vehicle to Matthew Hargrave, who they are in partnership with, is where I bought the vehicle from. Okay. I got the same type of estimate from Matthew Hargrave. I then talked to the supervisor the week of May 19th. I admit I was already 2 payments behind, and that was because I was still catching up from when I had to pay for the vehicle being hit. But that's neither here nor there. I explained to the supervisor of Smartway Auto that if you give me a month, I'll catch up on the 2 payments. Just please put me in a new vehicle. He said, I'm going to give you a week. If you don't have it paid by a week, I'm canceling the contract. Your Honor, I would also like to point out that the contract was 41 payments, and then I had to decide if I wanted the vehicle. I was already halfway through the payments. So it was my intention to continue to pay on the vehicle. But how can I pay on a vehicle that I don't have, that also I can't afford to get fixed, that was their responsibility, and it's their vehicle?
All right, thank you, sir. Madam Counsel, as it relates to the motion to set aside the default judgment, it sounds to me that like the plaintiff, strike that defendant in this matter, has shown good cause as to why he was not able to get into the zone. We've had some of those kind of problems. The more complicated issue here is, of course, as you may presume, the issue of whether or not he's able to show that there's a meritorious defense to the claim. He says that this was a vehicle that was under lease and that there was an agreement to make repairs. And in that window where he had damages to the vehicle, that it is at that time that this contractual breach occurred. Talk to me, if you will.
Sure, Your Honor. So yes, there was an agreement that was executed on January 12th of 2017. The defendant purchased or leased the vehicle from Matthew Hargraves. So I don't want to necessarily say he's trying to maybe assert a lemon law, but if we're teetering towards that area, Matthew Hargraves is the seller, Smartway Auto is the financer. Per the agreement that the defendant signed, he was to be responsible for all maintenance and repairs. I believe, based on looking at the sort of client file, the history here, shortly after the contract was executed, the defendant fell behind in his payments, not because of mechanical issues, but because he had some medical problems that affected his ability to work. From there, he was never able to catch up, Your Honor. So they would pay a little, would get on a payment plan, do partial payments. And then, yeah, as we all know, we got a 2007 car. So at the time, 10 years old, something happens that he is then responsible for. But you know, per his agreement, he agreed to be responsible for any maintenance and repairs. I don't have any records that we agreed to be responsible for any of the repairs. I know that's inconsistent with what my client has ever done. I don't think my client has ever agreed to be responsible for repairs of a vehicle, because that solely falls on the lessee or the defendant in this matter. So I would be happy to attempt a resolution, but I'm not hearing good cause to set this default judgment aside. Like I said, if we're really coming down to maybe something was wrong with the vehicle when he purchased it, he would have to seek that from the seller, which is not my client.
I just, Your Honor, if you don't mind.
I'm listening to you.
I'm sorry, my apologies.
I'm listening to you.
I actually caught up on the payments. What she's referring when she said medical condition, I had a heart attack back in 2018. I caught up on the payments. I also did not pay for the tow truck to come and pick the vehicle up from my house and take it to Matthew Hargrave. That was coordinated by Smartway Auto. Smartway Auto coordinated the tow truck. So I haven't had the vehicle since the week of May 20th. It's been sitting at Matthew Hargrave.
Just the week of May 20th of what year?
Of 2019.
All right.
So and so knowing how Smartway Auto operates, if I was so behind on payments, I got all the way to May of 2019 with their vehicle, which, by the way, has a system on there that cuts off the vehicle when you're behind on payments. So obviously still, I did enough from 2017 to 2019 to continue to have the vehicle while the vehicle was cut on. The only way I stopped paying on the vehicle is after Smartway Auto, the supervisor, decided to say, if you don't have everything caught up within a week, I'm canceling the contract. That was his words. 1 week, I'm canceling the contract.
All right, sir. And you were behind at that time, true?
I admit I was 2 months behind, and I told him that if you give me the end of this month, I said I started a brand new job work for the University of Michigan. I'll have everything paid off. And plus the fact that what my history has shown is that I have been paying on the vehicle. So I haven't shown anything as far as a character default that my word wasn't good, because I still had the vehicle for almost 25 payments. He decided that if you didn't do it within a week, mind you, they had the vehicle already. He already had the vehicle. If you didn't pay in a week, I was canceling the contract.
All right. All right. I've listened to the motion to set aside the default judgment in this matter, which the court previously took under advisement. The two prongs that are required in order to set the default aside. Number one is that there must be a showing of good cause for the inaction is not appearing. And it does appear the defendant has shown good cause. He had some difficulty in getting into Zoom, and he exercised significant diligence in trying to make contact with the court, and then brought this motion. The second issue is that he has to establish an affidavit of meritorious defense. That was not set forth in the document, but I gave the defendant the opportunity on this record to establish the meritorious defense that he may have in this matter. And he's raised some issues regarding repair of a leased vehicle, the agreement by an agency to effectuate a repair. And then Mr. Jameson has been forthright in that he was behind on the installment contract that's associated with the quote unquote lease agreement regarding the vehicle. When in default on the lease agreement, it is a discretionary matter to the holder of the note on this matter as to whether or not they will go forward on their rights under the contract, or whether they will delay in doing so and allow for the contract to be paid off or paid out, and things to be set back on course. In this instance, the the holder of the agreement decided that if the defendant did not pay within a specified period of time, i.e. 1 week, according to the statements of Mr. Jameson, that they would in fact go forward and execute on their rights under the motor vehicle lease agreement, which, by the way, that document sets forth in a pertinent part that the vehicle has no warranties, guarantees, et cetera, et cetera. So it looks like that was an as-is purchase back in 2017. The issues that bring the matter before the court now relate to some 2 years after that time. It does appear to me then that under these circumstances, the plaintiff had the right to, in fact, execute upon the contract by foreclosing on the deal, if you will, and requiring that the defendant either pay out or that the contract be, as was indicated, be canceled. That is what has brought this matter before the court. I can, under these circumstances, find that there is a meritorious defense to this claim. Defendant may have rights to sue on other promises that might have been made to him, but under the terms of the contract, this is if you flip it, if the defendant is fully in compliance in the contract and someone comes and takes his vehicle and he's in full compliance, the defendant is entitled to get his vehicle back and probably to other damages because he is in compliance. On the other hand, the defendant is not in compliance under the contract, notwithstanding his character before that time. If he breaches the contract, the plaintiff in this matter has the right to execute upon that breach. And the breach of the contract is established by the admission that there was some 2 months that was behind, and the plaintiff then executed upon that breach, and that's what brings the matter before the court today. For that reason, I don't find that there is a meritorious defense to the claim asserted by the plaintiff in this matter, and because that second prong is not met, then the motion to set aside the default judgment will be denied at this time, as there is no meritorious defense set forth to the claim in this matter. That is my order. The judgment will remain in full force and effect. Now, Madam Counsel, you indicated that your client might be willing to talk about numbers. If there is some issue on numbers, I could put you in a breakout room in that regard, or payment plan. So you can take a moment to do that. If Mr. Jameson wants to talk and what have you, I'll put you in breakout room number 1. And if you can talk about this, that would be great. If not, then everybody knows what the court's order is at this point.
Your Honor, can I ask a question before you, can I ask a question?
Yeah, go ahead.
So my question is this: even though he took the vehicle before he decided to cancel, and I don't have the vehicle, he took the vehicle before he decided to cancel. Okay, and I couldn't drive the vehicle, and they
Okay.
and
Let
the
me stop you. I understand your question. What your question is that you disagree with my ruling, and you can certainly appeal me. But here's the critical thing that you want to think about that. Were you in default on the contract at the time that the contract was canceled? That's the question that you want to think about. And if the answer to that, no, you cut me off. If the answer to that question is yes, you'll have a better understanding of my ruling. If you were not in default, then boy, I understand why you would be really concerned how I could make such a ruling. But if you were in default, that would be something that you want to consider. All right. So I'm going to give you a chance to speak with Ms. Bailey and talk about this, see if you can get anywhere. If not, then you've got my ruling on this. Now, there are the notifications. Good day to both of you. Just click into the notification. Ms. Bailey, Ms. Moody, did you get the notification?
Not
I
yet.
did, but yeah, you gave it to the wrong Kara. Miss Moody was on this case.
Oh, I'm sorry. Ms.
Notice that, yeah.
Yeah, I sent it to Ms. Bailey. Ms. Moody, I'm sending you a notification. All right, sorry about that, ma'am.
You're fine.
It's the first mistake I made this week, but it's early.
I got it, Judge. Thank you.
Good day. The court is called in case number 21-157473. This is Midland Management Incorporated versus Alexis Griffin. The matter is before the court on the file of a small claims matter that was removed to the General Civil Division. I do see that an answer to the same has been filed in this matter. Your appearance at this time, please.
Sarah Bailey, P73071 on behalf of the plaintiff today.
All right, thank you, Ms. Bailey, and I think I was trying to send you somewhere else earlier.
Yeah.
Thank you for being here. All right, I'm looking now for Alexis Griffin or counsel for Alexis Griffin. Anybody, Ms. Griffin, if you're on the Zoom?
This is Alexis Griffin. Good morning, Your Honor.
Oh, thank you, sir. Thank you, Mr. Griffin, and good morning to you, sir. All right, so I see that, let's see what happened here. 1 second. All right, now, it said something about an appeal from small claims. I think this was just a removal. Is that correct?
Yes, sir.
All right, so, Madam Counsel, update me on what's going on here, please.
Your Honor, I'm not sure why we didn't file in small claims. I guess I'm confused about that part of it. But this is a simple credit card matter, Your Honor. We're the successor in interest to Credit One Bank. We sued for $896.52. My understanding from Mr. Griffin's answer is that he's not disputing any of the allegations in our complaint. We did send him a consent judgment, but it was not returned.
Okay, you got a little cloudy there at the end. I heard you up to where you said it looks like he's not disputing the elements of the claim, and then you said something at the end.
Oh, just that we sent a consent judgment to him because he wasn't disputing any of the allegations, but it was not returned.
All right. So, Mr. Griffin, what's going on here? It does look like you agree with the statements based in the complaint, and that you're not really defending against that.
Yeah,
Go ahead, sir.
yes, sir, Your Honor. I'm not disputing the amount that I owe. I'm just asking the courts today to allow me to set up a partial payment towards this amount of the 896.92 without any interest or any court costs. Not disputing it. I just wanted the courts to allow me to set up some payment plan.
All right. So you said a lot. You said a whole lot there. The payment plan is certainly not.
I'm sorry, Your Honor. I'm
Also
sorry.
said no court costs, no. So what is the total amount of the judgment, Madam Counsel, that you're asking the court for?
The total amount of the judgment would be $1,017.32. So that includes our principal damages and $120.80 in court costs.
All right. And so Mr. excuse me. It sounds like Mr. Griffin wants to see if he can get a compromise on that amount. What are you offering by way of settling out on it, sir?
I'm sorry.
Go ahead.
I was looking at $150 per month.
That seems like a reasonable payment, but if you wanted to get kind of like the no interest or get some of it off, you would have to ask for something that's a more aggressive payoff. So if you were going to say you make 2 payments, you might be able to try to negotiate with Madam Counsel to get it working.
I mean, I agree, Your Honor. It's hard to do a payment arrangement and forgive the court costs that my client has already expended. I mean, $150 a month is certainly reasonable for a payment arrangement. It's just, I guess I'm still having a hard time forgiving the court costs.
Yeah. So if you were saying that you pay it in two lump sum payments, this month and next month or next month, the month after that, you might be able to talk about something, but you know, at the 1,017 court costs included, it's kind of hard to break that out to anything else. But I give you the 150 a month, that's a reasonable request.
Okay.
Makes sense to you, Mr. Bailey? Mr. Griffin, I'm still stuck on Bailey, huh?
Yes, yes, Your Honor.
Gonna make everybody Bailey today. All right, I will enter the judgment. It seems like there's a consent. I'll enter the judgment by consent, and I'll allow for the monthly payments of $150. What part of the month would you wish the 150 to commence, sir?
You're talking to me, Your Honor?
I'm talking to you, Mr. Griffin, and
Okay.
I'm looking at, we usually start the payment on a particular Friday.
Okay.
So we are in October and we are, this Friday would be the 22nd. So if I put it for November the 5th, November the 12th, which one works best for you?
November the 5th is great. I was gonna ask you that. November the 5th would be great for me, Your Honor.
All right. We'll put that in the judgment, November the 5th, 150. And then about that time every month, that first Friday would be your, when the 150 would be due.
Yes, sir. Your Honor, excuse me, I'm asking the plaintiff, can they send me some type of payment receipt or payment booklet so we can be on the same accordance with the payments?
Yep, how it works in our office, sir, is the judgment is your first notice of payment. And then once you make a payment to my office, it's automatic for my financial department to send you a letter right after that payment with the new balance and the fact that they received the payment.
Okay, very good.
All right, so counsel, you can submit your judgment to the court. I'll note that it is by consent on the record together with the payment plan. And Mr. Griffin, I do wish you well. You can email that judgment to Latifah.Hunter, that first name Latifah, Latifah.Hunter at 36360th, 36districtcourt.org.
I apologize, Your Honor. Can you give me the email address one more time?
Yes, ma'am. That's Latifah, Latifah.Hunter at 36, that's 360th, 36districtcourt.org.
.org.
Okay, and I'll have my staff email that judgment over, Your Honor.
All right, sounds good. And you'll get a copy of it as well, Mr. Griffin.
Thank you,
And
sir.
what your first payment date is, and I wish you well, sir. Good day
Thank
to
you, Your Honor. Thank you, and have a nice day, Your Honor. Thank you.
Thank you.
All right, the court now calls case number 21-160112. This is Austin Hunt versus General Motors LLC. The matter is before the court set on for a hearing on today's date. Looks like, all right, well, your appearance for the plaintiff, Austin Hunt, please.
Adam Alexander, on behalf of plaintiff, P number 53584, Your Honor.
Thank you, Mr. Alexander. Good morning to you and for a defendant in this matter. Counsel, your appearance, sir.
Good morning, Your Honor. Forrest Becker, P72530 for General Motors.
All right, thank you, Mr. Becker, and good morning to you as well, sir. All right, so I'm trying to see if this has been up before me before. I know it started with my predecessor. Well, maybe since I've been here. All right, so somebody update now. Where are you with things now?
There hasn't been a hearing, Your Honor. This is a lemon law case, and Mr. Becker and I probably have 10 or 15 cases pending all the time, so we work pretty good together. Maybe if we could just get 90 days of discovery, and if Mr. Becker would agree, and if the judge would allow it, if we could get the MCR case evaluation, that often that's successful in settling these cases.
Yeah, absolutely.
All right. All right. I don't know why, I hate 90 days, especially for lawyers that work real well together, but I'm constrained by the fact that there's so much collegiality here and that you have a number of cases that are pending all the time. So that excites me a little bit. So I'm going to go ahead and grant the 90-day open discovery. And you were requesting mediation in this matter? Because we usually, okay, so which way do you usually get that set up? Because we don't usually deal with the tribunal. And I issue an order allowing for mediation through the tribunal. Is that what you're expecting from me?
If that's, you know, allowable, Your Honor, we would like that.
Yeah, there used to be we used to have a normal process because the court administration had some connection to doing that. What I do is I tend to just issue the order for mediation at the tribunal and then let the lawyers get that set up from there. I've not known the tribunal to reject, money, so it should work out. Or it should work out okay. All right, so I'm going to set it I'm going to open discovery for the next 90 days, and then I'll set a hearing just beyond that time if I can find a calendar that puts me out to that far. So that's going to put me in January. So just 1 second.
Okay, what you want to beginning of January or middle?
Yeah, probably early in January.
January.
No, you better put me in the middle of January.
Middle. Okay, so January 17th.
January 17th, 2022. And I'll set that at 9:30 a.m. And I won't put any other, well, let me do it this way. What I'll do is I will issue an order relative to the mediation issue. And my order also will be a bit of a scheduling order, and that scheduling order will indicate that you can file motions to set them to a hearing on that January 17th date, so long as you allow at least 7 days for the other side to respond.
The 18th, Judge, the calendar is blocked.
18th, that date has to change to the 18th. I'm receiving some calendar information. January 18th, 2022, 9:30 a.m. Discovery is open for 90 days, and I will set that date for a final pretrial conference. And on that final pretrial conference date, there will also be a motion hearing date, dispositive and otherwise. And as long as you allow the other party at least 7 days to respond to any motion that you file, I will hear the motion on the 18th. And that'll all be in my order that you'll get from me shortly.
Thank you, Your Honor.
Thank you.
Anything else? All right. Thank you. Good day to the two of you. Good to see you.
You
You
too.
too. Thank you.
Yes, sir.
You good?
Yeah, I'm good. I just gotta make that call.
Oh, okay. You go ahead and do that. I'm gonna shut this down for a moment. We need.
Okay.
All right.